first with Mr. Harris's permission.
Good morning, Your Honors.
I'm sorry, go ahead. Go ahead.
Good morning, Your Honors. Again, appearing on behalf of Mr. Tommy. My number is 3988.
Attorney Sabree, your audio went out.
I'm sorry.
Audio went in and out. Can you say that one more time?
Yes, Samuel Chirikian, appearing on behalf of Mr. Tommy Miller. My P number is 29888.
Thank you. Mr. Miller, can you state your full name, please?
Tommy Nathaniel Miller.
Thank you. And Mr. Harris, Christopher Harris, can you unmute the device, please?
Yes,
Can you state your full name for the record?
Christopher Harris.
Okay. And also Attorney Harris, Wyatt Harris, are we waiving Mr. Sewell's presence today?
Yes, I would waive Mr. Sewell's presence today, yeah,
Okay.
for the purpose of this hearing.
All right. Attorney Sabree, you stated that you are requesting adjournment for additional discovery. Can you let me know what that is?
Judge, let me tell you that this sounds like it was kind of a mutual affray, a number of people involved, a number of officers involved. I did not receive any digital discovery as of yet, and I think it's very important that I review that before we make a decision how to proceed.
Okay, Attorney Harris, do you know if you have digital discovery?
I don't believe, I'm not sure, Your Honor. I got discovery, I just didn't get a chance to look at it. Got it just late yesterday.
Okay, Mr. Sawaki?
Both of you gentlemen should have received discovery yesterday. I sent it out. The only one who doesn't have discovery is Mr. Winters, and that's because I did not have his email address, so I could use his P number and send everything to him.
Okay. So digital was sent yesterday.
I'm sorry, I didn't see it. All I got was the paper.
It's sent from a different email, right? Evidence.com. The prosecutor's resending it right now.
Thank you very much.
Okay. With the digital discovery being sent, you will have the 16th available.
Let me look, Your Honor.
I'm sorry, what date were you suggesting, Your Honor?
June 16th.
That's fine. For PCC, correct?
Oh, no, that was for an exam date. I didn't know you still needed a PCC digital discovery set.
I can't do an exam on the 16th, Judge.
What day that week can you?
Either 21st or 23rd.
Your Honor, I may be in a murder trial starting on the 21st.
Does the 23rd work, Judge?
No, Attorney Harris said he's in a murder trial that week.
Right.
Mom.
I guess you all let me know because I days that don't work.
Judge, is it possible we could do the 30th?
That works for me, Judge.
That works.
All right.
June
You're already
30th.
name the time.
Let's do 10 o'clock.
That's for what?
Mr. Miller, Mr. Harris, your exam has been set for an in-person preliminary examination for June 30th at 36th District Court at 10:05 a.m. Do you understand that?
Yes.
Yes.
Okay, anything else from either party?
Can we confirm email addresses? The two gentlemen that
June
received,
30th at 10 o'clock.
Attorney Sharifian, can you provide your email address to the prosecutor?
You want me to put it in chat, or I can just tell you right now?
You can just say, we just want to make sure.
Audio was really bad.
Okay,
Actually, just put it in the chat and I'll send it to the prosecutor.
For that.
Yeah.
Thank you very much, Judge.
Attorney
Does
Sharifian,
that
it was all.
conclude this matter?
We couldn't hear anything. Can you just put it in the chat? Does he mind if I
I'm
say it
sorry.
out loud?
I'm putting it in right now. I have trouble hearing you. You're trouble hearing me.
Down.
Mr. Miller?
Yes.
Go and log off.
Excuse me.
You can log off. You're all set, sir.
All right, thank you.
You're welcome.
Christopher Harris as well?
Yes, you're all set. Okay. Mr. Meyer, I don't have a case up for you today. I don't have an attorney check-in for you or anything on the docket with your name. Do you have a deputy come over, so I can talk to him or her? Mr. Meyer?
Yes,
Do you have a deputy come over so I can, clarify why you're here today, because I don't have you on the docket?
all right, I'm here for a tether release, personal bond, at Elmhurst House in Linwood and Elmhurst. My last tether I just received like 2 days ago. It was kind of broke. It didn't have a charge to it. It wouldn't charge up, and I had to violate, and I came back. I came right back, and I'm just here to see if I can get a tether release today. But my next court date is August 29th.
I have that, sir. I got it. I got it.
Yes,
Okay.
for his tether release.
Okay, let me get your file and, get the email from the tether unit and I can address it, okay?
Okay.
Attorney Jerry Harris, good morning.
I'm here, Your Honor.
What's going on with your case?
I actually had it marked on my calendar for 2 days, and I gave my client the June 8th date. So I'm just wondering, could we zoom in on June 8th for our PCC?
That's fine. No problem.
Okay, thank you.
You're welcome. See you then. I just put on. Thank you. Okay, Attorney Bradford.
Good morning, I'm ready.
Okay. This is case 2356707, the people of the state of Michigan versus Jaquair Davis. Mr. Davis is charged with one count of weapons carrying concealed, set for an exam today at 10 a.m. Mr. Garrison.
Good morning, Madam Danielle. Here on behalf of the people, P 85495. Good morning, Judge, to you and your staff. Cody Bradford with Neighborhood Defender Service, P85944, on behalf of Mr. Davis. Judge, because we are set at 10 o'clock, I did zoom in early about discovery issues, so I would request to waive Mr. Davis's appearance for right now.
I will wait his appearance.
Thank you. I'm sorry.
No, I'm just saying, what's going on?
Judge, I know you've heard all of this before, but if I could just make the record. We have discovery issues in this case. You did sign a discovery order because I was missing quite a bit of potential body cam footage. We were set last week for a preliminary examination. I still had not received that missing discovery, so we set it over till today. I know the APA did reach out to the OIC, and it's my understanding that the OIC says there's no body cam footage. In particular, Judge, in the paper discovery, it does say that video of the incident was forthcoming. I did receive a video from the hospital emergency room, the camera up on their wall. But in addition to that, on page 7 of the paper discovery, one of the arresting officers has, as part of his report, that his body-worn camera was activated, and I do not have that discovery. As you know, Judge, the law requires any agency, prosecutor's office who has body-worn camera, that they have to have a written policy. MCL 780.316 requires the state to keep all audio and video recordings until completion of the legal proceeding. MCL 780.318 requires any agency with body-worn camera to develop a written policy for maintenance and disclosure of that audio or video, and it has to be in agreement with the act. In this case, I don't even think there's an issue with the Wayne County prosecutor's 90-day policy, because the alleged allegations in this case are from May 1st, and that's well within the 90 days. Even further, Judge, the DPD body-worn camera policy 304.6 3.3F says that if there is no body-worn camera footage, if there was a malfunction, if they dropped it, if something happened, the officer is required by DPD policy to have in writing the reason that the body-worn camera footage does not exist. We have no such statement here. The paper discovery says that specifically Officer Tucker, had his body-worn camera activated. This is the second prelim we have set, and I still do not have that discovery. I'd also add that the paper discovery says that one of the officers at the hospital, Mohammed Taraba, apparently gave a statement. I don't know if he gave a report. I do not have, the officer is Brendan Simpson, who works at the hospital. It says he would be present to testify at the exam to his statement. I do not have a statement from Officer Simpson. I do not have a report. The only thing I could think is that he talked to police and they put it in their own report. But all that to say, Judge, I'm missing this report from Brendan Simpson. I'm missing the body cam footage for Jordan Tucker. Second prelim we've been at. I'm requesting this case is dismissed for discovery violation.
Ms. Barrett. Good morning, Your Honor. I have spoken with the defense and the OIC, and up until yesterday afternoon, I did not have any explanation for defense. My apologies, but the OIC did reach out to me last night after doing some investigating on her own to find out the answers to defense's questions. The OIC actually is right behind me. She came in this morning to go over these, basically these questions. The explanation that I received, and you can ask the OIC on the record if you'd like, but she indicated to me, due to the fact this case transpires all within hospitals, DMC hospitals, 2 different hospitals, DPD is required to turn off body-worn camera in any possibly public area of a hospital. So she went and double checked with her officers and confirmed that they
they turned off their body worn camera. She
Judge, I'm
then,
sorry, can I interrupt? I don't know if it's Mr. Minor's video where there is a ton of background going on.
What?
Is there any way to mute? Thank you. I'm sorry, APA Barrett.
it's okay. So the OIC indicated that she confirmed that DPD officers on this case, including Officer Tucker, turned off their body worn camera when going into the hospital for their hospital policies at any time. So all body worn cameras were off at the time in both locations, because both locations of this incident, both the place, and actually, and I don't even know that DPD went to the initial hospital, but when they went to go actually pick up the suspect at the second location, it was also a hospital. And then OIC has conveyed to me this morning that she went and spoke to hospital personnel, the police at the hospital, and they indicated that they do not wear body worn camera for the same reasoning, due to the fact that they cannot record in public areas. Therefore, the indication on the report stating that video is forthcoming was in reference to the video that was sent, the actual surveillance video of the hospital. But I know that defense has mentioned a couple other things. I believe that we ourselves, the prosecution, do not also have a written report for Mr. Simpson, the hospital officer. Again, I do have the OIC here right now that can actually go into any more detail for you, Your Honor, since I do know that this is a request for dismissal, so she is here to speak to it. It is Officer Detective John Grants. Why don't you say your name, for the record?
I'm Detective Jennifer Adams, Detroit Police Third Precinct, Criminal Investigation.
Okay, go ahead.
So first, I want to give my apologies for I may have overlooked the request for the written statement for Officer Brendan Simpson. I think it may be in the case that I got.
Before you go into detail, Attorney Bradford, he's here.
If you could speak just a little more loudly, I'm sorry.
The microphone, this is really hard, well, plastic and little.
What's his way, sir?
He wants to introduce myself or okay. To answer the question, I do apologize to the defense regarding the written paperwork from Officer Brendan Simpson. I may have overlooked that. That is my apology, my mistake. However, when it comes to the body cams, so I did speak to this particular police authority, Brendan Simpson, and he did tell me that it's their policy, they do not wear body. And also, I did check the system again for Officer Lacey Sterling and Officer George Tucker's body cam, and I wasn't able to find anything. And I am aware that in most cases, officers are instructed to turn their body cams off when they go to the hospital. And to clarify what Madam Prosecutor was trying to explain, there is also a portion in our policy that states that when an officer is in a public area where there is reasonable expectation of privacy, that they must turn their body cams off. And I would only assume that this is why most officers are turning their body cams off in a hospital due to HIPAA. And that was also the reason why Officer Simpson, the police authority at ERH, told me that they cannot wear body cams to HIPAA.
And then for the Simpson report, what about that?
And that's what I'm saying. I do apologize. I overlooked that. I didn't even talk to him regarding that because I overlooked that.
I'm sorry if I may interject. I was not aware that, I was aware that we don't have it, but I was not aware that defense was asking for it. I noticed that we didn't have it too. I just assumed it was because it was a hospital officer and hence he didn't provide a written report. But I wasn't aware that that was requested. I know that I was diligently with Detective Adams here trying to find digital, but I was not aware that there was a request for that particular piece if there even is any, because we didn't have any either.
Well, yeah,
Prosecution.
that's just a question whether or not it exists.
Correct. But that question did not arise until just this moment. So I apologize that we don't actually have an answer to that one.
So we don't know if it exists.
I'm not sure if it exists. I could have asked that as well, had I. Usually they do an incident report, but in this case, I'm not sure if it exists.
Okay, Attorney Bradford, is there anything else outside of the body cam from Officer Tucker and the report from Officer Simpson that you asked for or you're asking for?
No, and APA Parrots is right. What I had conversed with her about was definitely the body cam footage last night in preparing for the exam today. I just noticed in the witness list from the investigator's report that it said that Officer Brendan Simpson will testify to his statement. And because of that, I didn't have a statement, and that's why I brought it up today. As for the body worn camera footage, I appreciate what the OIC and what APA Parrots is saying, that generally officers may turn off their body worn camera when they go to a hospital. However, in this case, the arresting officer's report clearly says body worn camera activated. So I don't know if we can use an argument that generally officers don't use their body worn camera in hospitals to negate that we don't have the video when the officer's report itself says that the body worn camera was activated. In addition to that, Judge, if Officer Tucker were to turn off his body cam, DPD policy requires him to have a written reason why he did not, or why he did turn his body cam off. We do not have that. Again, I appreciate what the OIC is saying, but we can't come later just to say an argument that maybe it was this and maybe it was that. Their policy has the requirement for a written reason why it was turned off to prevent exactly what we're here for. The speculating as does it exist, does it not? The report says that it was activated and we have no written statement saying the reason that it was turned off. I think that's enough, Judge, to dismiss it.
So it's not 10 o'clock yet, Attorney Bradford? I know you want it now, but I'm gonna have to wait till 10 o'clock. You didn't tell your client not to come, did you?
No.
So I'm going to recall this at 10 o'clock. In the meantime, if you can find any information about whether in this case, the video body cam was turned off or not, that would be helpful for the people. And also whether or not there's a written statement, as Attorney Bradford saying that in the packet that he received, there's a statement that exists with officers.
Okay.
Okay, so I'll see you back at 10. If it's 10:15, it's fine. We have a couple things going on.
I'm headed that way now, Judge. Thank you.
Okay, Attorney Phelps and APA Willis.
Morning, Judge.
Good morning.
Good morning.
That's all.
No, I have to put some around.
No, yeah, you're white. Yeah. Carmona, while you're waiting, you need to speak to London Shelton in the record room.
We do not, Judge. We did discuss things with her yesterday afternoon, so we're all set.
Okay, she is not connecting the audio. I don't know if you have her number, maybe you can.
I do, Judge. I'll give her a call.
Okay. Busier than usual. Literally 5 minutes. The form, the waiver form flag on here. Thank you. Okay. I couldn't take it. Okay, we're on the record. This is people of the state of Michigan versus Emmanuel Quinton Wiley. Case 2356016. Mr. Wiley is charged on this case with count 1, forgery of document affecting real property. Count 2, uttering and publishing a document affecting real property. Count 3, UCC filing false and or fraudulent financing statement with the half fourth offense notice. Mr. Wiley is also charged on case 2356156 with count 1, forgery of document affecting real property. Count 2, uttering and publishing a document affecting real property. Count 3, forgery of document affecting real property. Count 4, uttering and publishing a document affecting real property with the habitual offender fourth offense notice. Mr. Wiley is also charged on case 2355978 with count 1, uttering and publishing a document affecting real property. Count 2, forgery of document affecting real property. Count 3, UCC filing false and or fraudulent financing statement with an habitual offender fourth offense notice. And lastly, Mr. Wiley is charged on 2355769 with count 1, forgery of document affecting real property. Count 2, uttering and publishing a document affecting real property. Count 3, forgery of document affecting real property. Count 4, uttering and publishing a document affecting real property. Count 5, UCC filing false and or fraudulent financing statement. Set for an exam tomorrow at 9:30. Appearances.
Good morning, Your Honor. Latoya Willis, appearing on behalf of the people.
And good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Wiley, who's also present via Zoom. Mr. Wiley, can you please state your name for the record?
Emmanuel Quinton Wiley Pearson, yeah.
Okay. And Attorney Phelps, you're requesting to come here today before the exam tomorrow to request a referral for competency?
Yes, Judge.
Okay. All right, I appreciate you letting us know beforehand, instead of the day of the exam. And this will be for competency to stand trial only, or?
Yes.
Okay. Okay, so I'll have them referred, I believe 90 days is the time, right about now, then we have to wait, hopefully have some information.
And Judge, we will be in touch with the Forensic Center on our end too to try to facilitate it to happen a little bit faster. Do you have a review date for us to come back?
Let's do September 7th or 8th. Let's do 7th, Thursday.
Sounds good.
Great, thank you, Judge.
We'll do 9 o'clock.
Are we setting that as just a return for competency?
Correct, yes, yes.
All right, thank you.
All right, you all have a good one.
Thank you, you too. Mr. Riley, you're all good to sign off, okay?
All right, thank you.
Okay, yep.
I'll fill this out later. Okay. Mr. Welch. So tomorrow, our answer on board. No. We have 4 nights. Mr. Minor, give us a moment. I'm still trying to figure out, who is the target?
Let me just see this one. I was hoping they would pop one out. It's Miss Cole.
Right, yeah, that's a different facility. Right. Okay. People in the state of Michigan versus Jalen Welch, which is number 2, case 2356601. Mr. Welch is charged with count 4, conspiracy to commit stolen property, receiving and concealing a motor vehicle. Count 5, stolen property, receiving and concealing a motor vehicle. That's it. Set for exam today. Appearances.
Edward Milwaukee, P54828, we have people.
Minor Alexander Trout with the Neighborhood Defender Service of Detroit, P85948, appearing on behalf of Mr. Welch, who's currently president.
Please speak in the microphone.
Yes, good morning, Your Honor. Alexander Stroh with the Neighborhood Defender Service of Detroit, E85948, appearing on behalf of Mr. Welch, who is present in the courtroom. Mr. Welch, consider me loudly.
Jalen Wood. Good morning. Okay, today's set for the exam. I have a waiver form for me. Is it correct? Trying to show that your client is winning the exam today?
Yes, Your Honor.
Any objection from people?
No objection, Your Honor. For the record, people are dismissing count 4, conspiracy to commit stolen property, receiving, stealing, motor vehicle due to insufficient evidence.
Okay. Sure there's no objection to that?
No objection, Your Honor.
Okay. Take note of that. Okay, Mr. Welch. I'm going to ask a series of questions. If you don't understand me or if you can't hear me, let me know, okay? And make sure you speak up for the court for your response.
Okay.
Is it your wish to waive your preliminary exam today?
Yes.
Do you understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam today, the people would have to show that the probable cause standard, which is a lower standard in criminal law, but still standard, that the charges I read off, minus the conspiracy charge, was committed in the city of Detroit, and that you probably committed those crimes. Do you understand that?
Yes.
And then by waiving your exam today, that means the people do not have to prove anything or present any evidence. Understood?
Yes.
You also understand that you are not giving up the right to trial?
Yes.
Okay. Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will dismiss without prejudice count 4 for the people's motion. Bound over to Third Circuit Court, Frank Murphy Hall of Justice, 2 weeks from today, which will be June 20th at 9 a.m. for your arraignment on information, okay?
Okay.
Anything else from you, the party?
No, no, Your Honor.
Okay, well, have a good rest of your day. Thank you. And I'll make sure. Thanks.
Judge, I believe Ms. Shelton may have figured it out. I think she's just in the other room.
You can step up, she'll be right.
Okay, if somebody in the bedroom, let's hopefully it's her.
Good morning. I am sorry that I'm running movement. Okay. May I introduce you to my intern? It's that time again. This is Nadia. And hopefully I won't screw her head up. Yeah.
Okay, let's see, Attorney Carmona over here, your client's here.
Yep, we got it all set, Judge. Thank you for your patience.
Oh, Ms. Shelton is here, Judge. She's from the record. I have no. Yes. Okay, this is case 2357068, People State of Michigan versus London Shelton. Ms. Shelton is charged with count 1, assault with dangerous weapon, felony assault. Count 2, felony commission with motor vehicle adult advisory, set for a probable cause conference today. Appearance.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
And good morning, Judge. Brittany Carmona on behalf of defendant PH 6396, standing in for attorney of record Leanna Belcher. Ms. London, if you can hear us, can you please state your name for the record?
Ms. Shelton, say your name.
Judge, I don't know if she can hear us.
It says she has audio. That's it. Okay. Well, we see that she's present. You know her as Ms. Shelton.
Correct, Judge. Thank you.
Okay. I will waive her appearance for today. Do you have discovery, Attorney Carmona?
We did. We just received the last of the digital discovery yesterday, Judge. We're just requesting an in-person exam as everything else has been settled.
Okay. I have the date here of the 12th for scheduled exam. That might not work. You have, let's see. Actually, the 12th does work. You have 9 o'clock available?
The 12th at 9 o'clock would work perfectly, Judge.
So June 12th at 9 o'clock, and please make sure you let Ms. Shelton know. They usually put on the record, put them on notice.
Of course, Judge. I'll give her a call right after we exit the meeting.
Okay, thank you.
Thank you, Judge.
Have a good one. Mr. Minor?
Yes.
Okay, we talked to your attorney, and Ms. Coulter stated that she is not going to log on, and that she recommends that you remain there until you are evaluated. So I can't move forward without your attorney present. So you need to be evaluated. It's my understanding she said that she walked away from Maryland from treatment. I don't know if that's true or not. I can't get into the details of it, but she stated that she recommends that you stay in Wayne County Jail until you are evaluated. So I cannot move forward or change your tether condition based off of your attorney's representation.
All right, do you happen to know when is my evaluation?
That I don't know. If you want to wait, the clerk can call the forensic center, or you have deputy come over. Mr. Minor, the deputy near you?
I mean, I'm short of hearing, but I guess I understand. I'm just gonna say it's evaluation.
Is there a deputy near you? That's what the question is. Is there a deputy near you?
And that is the forensics, isn't it?
Okay, well,
Is that the evaluation for the forensics?
is there a sheriff near you? Somebody who works there who can come to the camera?
Yeah. Okay. Bye, Sabree.
Okay, I guess we're done. I say bye, Sabree. Yeah, I'm not sorry.
Thank God.
Attorney Hamilton, what case do you have today?
I've got last name Gunn.
Oh, okay, Attorney Culpepper was retained today.
Okay. Awesome. Thank you so much.
All right, have a good one.
Yeah, you too.
Okay. So the people of the state of Michigan versus Lorenzo Wright, case 2356607. Mr. Wright is charged with count 1, weapons, dangerous weapon, carrying with unlawful intent. Count 2, aggravated stalking, set for an exam today. Appearances?
Good morning, Your Honor. Danielle Parrish on behalf of people P85495.
Hey, good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Lorenzo Wright. Right.
Okay, today is the day set for an exam. There was a sidebar off the record conversation with both Ms. Parrish and Attorney Riggins discussing Mr. Welch needing to be referred for competency. Is that correct?
Yes, Your Honor. I respectfully ask that you confer the competency from the responsibility. I've had several conversations with Mr. Wright. I did spend a few times in jail. I spoke to him on his phone at the time. I have my doubts that he fully appreciates everything that's going on in the situation, Your Honor. And I think that this young man just needs to be referred to competency to ensure that he fully understands everything and appreciates the potential liabilities of the case.
And I know you have another request regarding his bond, correct?
Yes, Your Honor. Mr. Wright has a personal bond with a GPS tether. I checked on his tether last week, and there was an issue with the address that he gave tether. I spoke with a sergeant and I gave them his mother's address. And the officer spoke with the mother. It was my assumption that he would be tethered out. That was last Tuesday that this happened. He is still in Wayne County custody. I spoke with someone at the tether unit Friday, and they explained to me that it could be because the tether unit is short-staffed. I don't know. I still don't think that is short staff. I don't think it's good enough reason to deny someone their freedom. They earn their freedom. So I'm going to make two requests. Number one, that we remove the tether requirement. My client is a caregiver for his mother, who's Mary Wright. And I have spoken with Ms. Wright several times. Ms. Wright is anxious to have her son home and to take care of her. And number two, if you're not inclined to remove the tether requirement, we just keep it the current bond.
Your Honor, if
I have one question. Yeah. Why? So he was out on tether, personal bond. How did he end up? Oh, he never was out. He never got the tether. Okay. Ms. Parrish.
Your Honor, I completely understand everything defense is saying, and I do not disagree with the statement that the fact that they are behind valid excuse. My only concern is these charges, one in particular of the defendant's charges, is stalking, which is serious, involves another victim, and I believe that is why he was told to be put on a tether. I understand again the fact that we don't want to be keeping people in jail due to the fact that they're behind, but I would be concerned by just removing the tether. I don't know if it is possible to have him released until the tether is available, and he return and have that tether put on. But I think that that was put in place due to the seriousness of these charges. And now the competency is coming forward. He does need to appear on those as well. So that would be my concern, and that is why I would object to just fully removing the tether.
Yeah. There's an unusual question on my behalf. I believe both Ms. Mary Wright and Bianca Wright are actually here. They're actually, Bianca Wright is the alleged victim in this case. Can we just ask Bianca Wright if she actually fears Mr. Wright? I believe this whole
You sure
incident.
you want to do that?
Do I want to ask her if she,
I will allow it if you're okay bringing her in here.
for that limited purpose, I'll ask her, absolutely.
Your Honor, is it possible to speak to her, or have the defendant, and these kind of charges, have the defendant just wait behind closed doors? I would think it would affect her, what she states by having the defendant right there as she's being asked, is,
Have the right to hear everything. This is not, it's not a private.
I understand. Do you mind if I just tell,
You can go
it's in
talk
case
to
the
him.
walkie's case, you mind if I just let him know so
Sure.
he knows what's going
We'll talk
on?
the
Okay,
rest.
thank you.
And she can stand right in the back, she doesn't have to come anywhere near you.
Okay.
Okay, we're back on the record on Mr. Lorenzo Wright, appearances.
Edward Milwaukee, P5488, apparently you have people.
Again, good morning, Your Honor, good morning to your staff, and services by Ken Riggin, P82125, on behalf of Mr. Lorenzo Wright.
Okay, and we took a moment off the record because Attorney Riggins requested a bond adjustment to have the tether removed, and Ms. Parrish said that she objected to that based on the aggravated stalking charge. And Attorney Riggins asked if the complainant witness, since she's here, come to the courtroom to discuss whether or her stance on that. And I believe Mr. Sawaki had an opportunity to speak to the complainant witness outside the hallway regarding that.
Yes.
Go right ahead.
First off, we have Mary Wright, Mr. Wright's mother, and Bianca, Wright, who is also a victim in this case.
No, I actually strike her also. I don't think it's right. There is one.
Miss Mary.
That's true, that's true.
Bianca.
Okay,
Mary
Ms.
Wright.
Bianca Wright, state your name for the record, please. Bianca Wright. Okay, I want you to understand that you're not pressured in any way to give any response that's not yours, okay? So we're in the middle of discussing Mr. Wright's bond condition right now, and the attorney has requested, his attorney has requested that his tether be removed. And the prosecutors objected to that. And Attorney Riggins, his attorney is asking that you come in and speak as to whether you object to that, having the tether removed, or whether you, or how you feel about that. And you are a complaint witness in this case, so you have a right to say what you would like or how you feel about it. So go right ahead.
I don't think he should be in jail. I think he should be somewhere where he can get treated or get some help for whatever is going on with him. You know, I'm not 100% sure of how his, you know, what he's thinking or how he's feeling. But overall, I just think that he needs to get some help.
Okay. The question specifically about the tethering.
About the tether. As far as like going home and have a tether, or like,
Right, being released from jail without a tether.
I feel like he could be released without, you know, without a tether. No.
You don't feel pressured in any way?
No.
Okay. All right, I appreciate it. I just wanted to hear what you had to say. Mr. Sawaki, you can step out the courtroom, Ms. Both, Ms. Wright, you all say.
Okay.
Thank you. Yeah, you're all set. Thank you. So Mr. Sawaki, does the people's position remain the same?
Yes.
Okay. All right. So he is supposed to be out on Saturday, Mr. Wright. What I'm going to do, he is being referred, I don't know if you know that, he's being referred today for competency. We have a date for September 7th at 9 o'clock for competency. It's been about a week since he's supposed to have a Saturday, correct?
It's actually been longer than a week. Tuesday, I spoke with the deputy and I I found out that the reason that he was not released, he gave them what the tether office considered a valid address.
Okay.
I gave them his mother's address and her phone number. She verified that he was okay to stay with her. He still was not released. I spoke with someone Friday, and that's when I was told that due to being short-staffed, he was still in jail, or they had not processed all their tests.
Okay, I'm going to go off of YouTube for a moment. I need the address that you are going to be staying at, because I want to send that to the tether unit. Sometimes they want to hear word as well. So you can provide that one. Mr. Wright, if you know,
I have.
Dr. Switzer? Regular. You come back to a couple.
Your Honor, if I may, for the case for attorney. He has no contact. She's asking for it. So I had to fill out the paperwork. He's coming back. Yes, sir. That's so hard to do. Yeah. All right. Yes, so no pressure. Oh, okay. You how you say Grace? Yeah, I thought you said Grace.
Now, my name's Aliyah. I work at Church. And I'm just, okay.
Thank you.
Thank you. You can come without attorney Rick as well. You don't have to, you don't have to. Mr. James. Why, have everything?
I know I'm getting ready to call your case.
Thank you, Judge.
Yes, I just need a signature, Judge Sabree. Always let me fill out.
I see on the front page right here, it looks like 100, and it's on.
And then I'm gonna give you this.
I'm not sure what that.
Thank you. So they're like, ooh. Attorney, oh, I'm just waiting for a prosecutor to come back.
Understood. Thank you, Judge.
You can change anything for mine, right? Okay, so I'm just gonna put, I did it. No, good, I'm just gonna put it back in like, so, I mean, August. I still don't know what he said. You know, you can still do something here. Good job. The one in the county jail. Oh. He said, I say three or something. Say three. All right, bye. See you in August. Yeah, see you. Get you out. And I do want to bring the same together. You can't put it after.
So Judge, the county forgot to bring 2 prisoners. I ordered them out at 9 o'clock, so at 10:30, they're gonna be a little bit. Where Coles is. Coles and on 1:30.
So the 1:30 is not really the problem, right?
Correct.
My determination, I guess in case he gets to this point, just so he won't miss it, because he sent this morning, right here on the front. Okay. And you'll see when we roll, with the whole, I didn't look for it. That's, I can't.
Bring it back. Madam Clerk.
I'm sorry.
Give it back to
this, yes, please. Thank you.
That's too much.
Oh, today at 1:30.
No, it's fine. Thank you. I just know sometimes Judge, we get to move myself.
So Mark, we have a case for, Mr. Nas Syed Suleiman.
Okay.
Okay, we're on the record. People State of Michigan versus Nas Mohammed Ibrahim Syed Suleiman on case 2356830. Mr. Suleiman is charged with one kind of robbery armed, set for an exam today. Appearances.
Edwin Milwaukee, P54828, hearing on behalf of the people.
Good morning, Judge. Neighborhood Defender Service by Gleno, PA 3424. Appearing on behalf of Mr. Syed Suleiman, who is not present. We have no explanation for his absence.
Okay, and that was the same issue last time you were here, correct?
At the last 2 PCCs, Judge, that's correct.
Okay, anything from the people?
He asked for a KPS, Your Honor.
Okay, I will issue a KPS. It'll be $2,000 cash surety. And Attorney O, if you do make contact with your client, you can schedule a walk-in to the courtroom.
Thank you, Judge.
Thank you, Your Honor.
This has been on the whole time. So with that, I am going to dismiss without prejudice for a discovery violation. Not that people were withholding evidence or the officer charged with contingent withholding evidence, but that there's no clarification or answer as to what that means with the body worn camera being activated on this case. We don't have what that is, and still don't have it at 10:32 today. So I will dismiss without prejudice. And Mr. Davis, just so you understand, that means that the people and the police can reissue this case once if they get discovery together. You understand that? Speak up.
Oh, I understand.
Okay, so today I'm dismissing for discovery violation. That does not mean this case won't be reissued, correct? Anything else from either party?
Nothing from the defense, Judge.
Thank you, Honor.
They went outside.
Yeah. Cause I don't know, I haven't seen any video either.
Oh, Dr. Adams.
I got time.
And I'll go back to when you do. Yeah, okay.
I'll fish around for it there.
People say the Michigan Mercy Ron Gregory Jim Gray, 2356827. Mr. Gray is charged with count 1, police officer assaulting, resisting, and obstructing individual from forth against notice set for exam day. Appearances.
Good morning, I'm Danielle Parrish on behalf of the people, P85195.
Good morning, Your Honor. Whitney Lemelin, E58914 on behalf of Levon Graves. Mr. Graves is standing next to me to my right. Please state your name for the record, sir. Levon Graves.
Okay, take the except for exam. This is my understanding. Issue of discovery.
Your Honor, the issue is technically it's insufficient evidence. I did speak, both of my officers needed, the necessary officers for this case are here. However, one of the officers is having difficulty recollecting some details. And unfortunately, I reached out to the OIC because there was no supplemental report for the officer to reference back to so that his memory can be refreshed. I sent an email to the OIC yesterday indicating that that is needed and to bring it to court. Unfortunately, the OIC did not get back to me, nor has the OIC appeared. He was, I don't want to say he, I don't know them personally, but they were subpoenaed, but did not appear. So unfortunately, because this officer does not have a report to refresh his memory, at this time, the people cannot move forward. I would normally ask for a adjournment. However, I do understand if it is, I did explain to them that if it is dismissed without prejudice, once everything is brought forward, we could reissue at that time.
Your Honor, we're prepared to go forward at this time. Make the motion to dismiss.
Okay. Thank you for being candid, Ms. Parrish. I am going to dismiss without prejudice, as the people are not able to move forward.
Thank you, Judge.
Thank you, Your Honor.
All right, is this bond now canceled, right? In this case?
Yes.
You're gonna go back to Macomb and then they'll put tether on you. All right, they still got you. They just need tether on you. All right, I'll talk to you.
Automatically cancel.
He just cut my junk off yesterday.
What's that?
No, I had to tell you.
You can step back, counsel, if you want to talk to
No, they have it, but you can.
Oh, okay.
No,
Thank you.
Got to move out of here. Hold on one second. Just let him step by him. She wants to step. Sit next to him.
My last case, I wasn't able to communicate with my client and I missed some things.
I remember.
I get it.
Oh, I see.
You want me to wait out in the hall?
Okay, I know I had to wait.
No, that's okay. I apologize. Thank you.
Tuesday.
On the heels of a busy Monday.
Right.
Right before another busy Wednesday.
Oh, yeah, Wednesday gets worse. I didn't put his date of birth.
You did not, thank you.
Because I didn't have.
Put it.
I'll take your. Okay, ready on Ms. Coles?
Yes, Your Honor.
Hey, this is case 2356423, the people of the state of Michigan versus Stephanie. Stefan Coles. Who's our? Okay. At all. Obvious charge, count one, weapons carrying concealed, count two, weapons carrying concealed, set for examination. Appearances.
Evans walking P5488, people.
Good morning, Your Honor. Christina Nelson of Neighborhood Defender Service on behalf of Mr. Kobe, 77960. Mr. Kobe is present here with the court. Please state your name for the record.
So far, we be correct.
Ready to proceed with the exam?
Yes, Your Honor.
Yes, Your Honor.
If there's anyone on YouTube or Zoom who may be watching and also a potential witness on this case, now we're trying to log off, staying in the courtroom. If there's anyone who will be testifying or may testify out inside the courtroom. Are you ready?
I have no preliminary here, Your Honor.
Oh, okay, good. Is there an officer in charge on this case?
Yes.
What's your name, sir?
Detective Garcia.
Detective Garcia, any objections, Attorney Nelson?
Sure, Your Honor. People call first officer Jacob Patterson.
Officer Patterson? Ask the court reporter, I'll stay right.
Yes, sir.
Okay. You can sit right here, the door opens in the front, make sure you put the microphone down and speak it.
Could you say your name and occupation for the record, please?
Officer Jacob Patterson, Detroit Police Department,
How long have you been with the Detroit Police Department?
6 years.
And were you on duty September 17th, 2021?
Yes,
And were you on duty in the area of Rush and Lafayette, to Detroit County Lane?
yes.
What was the reason for being in that area?
I was on a foot beat.
And who were you on patrol with?
Officer Rumschlag,
And at that time, what did you observe?
walking northbound on Rush. I observed a maroon Jeep parked on the east side of the street facing northbound.
And what did you observe about that Jeep?
As we were walking past the Jeep, I observed my partner illuminate his flashlight through the opening of the front of the vehicle, and I observed the defendant seated in the driver's seat.
And is that person here today in court?
Yes,
Did you point or indicate his location and piece of clothing he may be wearing?
sitting in a chair right there in a green shirt.
Let the record reflect that the officer has identified the defendant.
More questions?
What did you do next, sir?
As my partner illuminated his flashlight, I observed a handgun in the lap of the defendant.
What happened next?
I made my way over to the driver's side of the Jeep and made contact with the defendant. I asked him multiple times if he had a CPL, and he stated he does not. Prior to that, as I was walking out, I observed him reaching into the backseat area of the Jeep.
What happened? Prior to the defendant not having, stating that he did not have his, or strike that. What happened next?
Well, since he advised me that he does not have a CPL, I had him exit the vehicle. As I had him exit the vehicle, I observed a holster on his person. Placed him in handcuffs while I observed my partner at the passenger of the vehicle exit the vehicle as well.
Having a holster on his hip, what does that indicate to you in your experience?
My experience as a police officer with multiple CCW lockups, that indicates that he was carrying a handgun.
What did happen next?
As I was standing by with the defendant and the passenger of the vehicle, observed my partner checking the backseat area of the handgun because I no longer observed the handgun in the defendant's possession when I had him exit the vehicle. The defendant stated that the handgun was in the trunk, where my partner advised me he had located it.
What happened next? Did you do anything next?
Defendant didn't have CPL, he was arrested for CCW motor vehicle.
I have nothing further for this commission.
Cross. September 17th, 2021 was not your first contact with Mr. Covey, was it?
My first contact, I don't recall.
You hadn't observed him walking in that neighborhood in the past?
I don't recall.
Don't recall. You haven't seen him open carrying in Greektown?
There are multiple people that open carry in Greektown.
So you're not familiar with him specifically? The holster that you recovered from his hip was an open carry holster, correct?
I do not recall.
As you approached Mr. Covey's Jeep, you were approaching from the rear passenger side, correct?
Correct.
And it was nighttime,
Correct.
and your partner shines a light into the passenger side window.
Correct.
And it was at this time that you observe a pistol in Mr. Covey's lap.
Correct.
And approximately the amount of time that elapsed between the shining of the light and you making contact with Mr. Covey on the driver's side is less than 10 seconds, correct?
I couldn't give you that answer.
Would watching your body worn camera refresh your recollection of how much time elapsed between you observing supposedly this handgun and you making contact with Mr. Covey on the driver's side of the vehicle?
Yes.
May I join the Zoom, Your Honor? The waiting room. You identify this? You identify that?
Yes.
Is that your body worn camera from that question?
Appears to be.
This is where your partner is flashing the light at 19 seconds. And this is you coming around and making contact at 25 seconds. Is that correct?
Yes, so this is my partner's body camera.
Sorry, wrong one. Let's try this one. So it's you walking behind your partner, correct?
Correct.
Okay, and we're at approaching the Jeep is up here. 17 seconds, 19 seconds. 2 seconds. Okay, light flashes in at 29 seconds. You're around and we're at 34 seconds. So we're actually less than 5 seconds, correct?
Correct.
Okay, and at the time you made contact with Mr. Kobe on the driver's side of the vehicle, there was no weapon in his lap, correct?
Correct.
Okay. And you searched the back seat where he was reaching, correct?
I did not.
Your partner did, correct?
Yes.
And there was no weapon. Oh, whoa. That's bad. Thank you. And there was no weapon recovered, correct?
From backseat?
Correct.
Correct.
So it's your testimony that there was a weapon in Mr. Kobe's lap, and somehow in less than 5 seconds, that weapon went from his lap to in a bag in the trunk of the car?
Well, he was still manipulating something in the back seat when I was trying to make contact with him at the front driver door.
And the weapon was recovered in a gun case in the trunk of the car, correct?
He was recovered from the trunk, yes.
In a case,
I can't recall if it was in a case or not. I wasn't the one recovering.
and it was unloaded.
I can't recall.
There is a seat between the trunk and the driver, the front, right? It's a Jeep, it's a multi-seat vehicle.
Yes,
You cannot reach the trunk from the driver's side, the driver's seat.
it's easy to throw.
You wrote a report in this case,
Yes,
and that report includes all important details.
yes,
You knew that report would be relied on by the Wayne County Prosecutor's Office,
yes,
making charging decisions, and to refresh your recollection as to what happened.
yes,
This case is over almost 2 years old at this point.
yes,
So your memory was fresh at the time of writing the report.
yes,
In fact, you reviewed your report today in order to testify.
yes,
In that report, you made no mention of seeing something being thrown or a throwing motion.
correct.
So again, it's your testimony that you observed something in Mr. Kobe's lap, and in less than 5-second period, that object ended up in the trunk of a car outside of the grab zone of Mr. Kobe.
Like I said, he was still manipulating something when I was attempting to make contact with it.
You wrote in your report that he was reaching into the back seat, correct?
Correct,
Okay. And nothing was recovered in the back seat, correct?
correct.
Okay. You ran these weapons through lead, correct?
Believe my report would refresh my memory.
Attorney Nelson, you said weapons. Right.
You ran the weapon through lead? The gun? The pistol?
Believe so.
Or it says they were registered. If I can approach, Your Honor. Sure.
Yes.
The gun that was recovered from the trunk of the vehicle was registered to Mr. Covey, correct?
Correct.
No further questions for this witness. Can you redirect?
Yeah, weapons were recovered.
The 2 weapons were recovered.
Another problem.
Redirect, Your Honor, or recross. Both weapons were in gun cases in the trunk, correct?
I don't recall exactly. As I stated before, I wasn't the one that recovered.
And both weapons are registered to Mr. Covey.
Yes.
And both weapons were unloaded.
The state before I wasn't the one recovered. I couldn't answer that for you.
Are you familiar with the law regarding transporting of weapons in a motor vehicle if you don't have a CPL?
Yes.
And in fact, it is legal to transport a gun in the trunk of your car if it's in a gun case and unloaded, correct?
Correct, with the ammo being completely separate from.
Right. Yes, and so unloaded, separated in a case in the trunk of your car, they're registered to you.
Yes.
And both weapons that were recovered were in Mr. Covey's trunk, unloaded in gun cases registered to him.
I'm gonna object. The officers already testified that he didn't observe what was in the trunk. His partner made the recovery.
Ask and answer.
Asked and answered.
It was your testimony oral earlier that Mr. Covey told you that he did not have a CPL, is that correct?
Yes.
You asked him multiple times, correct?
Correct.
Would your body worn camera refresh your recollection as to whether he actually responded?
Yes.
May I approach, Your Honor? I don't know how to share my sound. Oh, yeah, you just approach. He actually responded.
Yes.
Let me log you up. Can I help?
Yeah, I'm leaving the meeting. Are you getting slower on it, Your Honor? Try to connect to my cell phone internet. Better reception. And at this moment, you're about to place my handcuffs, correct?
Correct.
Alright. And at that point, you've asked him if he has a CPL 3 times, correct?
Correct.
He has not responded?
It's hard to hear on the body cam footage of his response.
I heard him say multiple times, I put it up. Did you hear him say, I don't have a CPL or no?
In that body cam footage, I couldn't hear.
And at that time, prior to verifying whether he had a CPL, you arrested him.
Say that again?
Prior to verifying whether he had a CPL, you placed him in handcuffs.
Yeah,
And he was not free to leave.
he was detained.
And at that time is when your partner searched the backseat of his car.
Through the chain of events, I believe so.
And this is prior to running his ID through lean.
Well, when an officer asks you for a CPL after seeing that you're concealing a handgun and one is not produced, usually leads me to believe that you do not have a CPL.
Failure to display a CPL is a civil infraction, correct?
Correct.
It's not an arrestable offense.
Also, not having a CPL is a arrestable offense though.
But you don't know whether at this time, when you place Mr. Kobe in handcuffs, you haven't gotten an answer to your question about whether he has a CPL or not.
Well, from my report stated, that he stated, no.
Right, but for your body worn camera, which I heard the audio pretty clearly, you're asking him 3 times if he has a CPL. He says, I put it up, and then you order him out of his car.
I'm gonna object counsel's testimony to what she heard.
It is, I'm listening, it is testifying. Okay. The witness has said that he said in his report that that the defendant said no, and he's stating that when his memory is refreshed or recollected, that he could not hear on the video response.
No further questions at this time.
No further questions, please, Ms. Ryan.
Thank you.
Any other witnesses?
Yes, Your Honor, people call Officer Bailey, and I'm gonna apologize ahead of time. Thank you.
Yes. Make sure you open up the door and give it the microphone. Whenever you're ready.
Sir, can you state your name and occupation for the record, please?
Bailey Rumschlag, I'm a police officer in the city of Detroit.
How long have you been a police officer in Detroit?
6 years now.
Were you on duty September 17, 2021?
Yes.
And were you in the area of Rush and Lafayette, city of Detroit, County Wayne?
Yes.
What was your reason for being in that area?
We're on a foot beach in Greektown. It's very busy at nighttime.
And at that time, what did you observe?
There's a red Jeep parked in front of time for the bar called Ready for Everyone. Walking along the passenger side of the Jeep, I looked in, observed the driver, Mr. McGee Coates, seated in the passenger seat. I'm sorry, seated in the driver's seat.
And is, that gentleman in courtroom today?
Yes.
Would you, give us his location, name, meeting, where?
I was wearing a green jumpsuit, seated next to the defense counsel.
Let the record reflect that the officer has identified the defendant. When you look into the vehicle, what did you observe?
I observed Mr. Coates, he had a firearm in his lap. He was handling money, and there was multiple baggies of suspected marijuana in his lap next to the firearm.
And what did you observe next?
I asked him if he had a CPO. He stated yes, to which then he grabbed his gun and put it in the back seat, dropping the mag from the mag well.
Did he ever produce the video?
No.
What occurred next?
Advised my partner, my observation, my partner asked him again, do you have a CPL? He said no. I observed my partner detain him for further investigation for carrying concealed weapons. I detained the passenger of the vehicle. I can't recall his name right now. I have to refer to the report. Just for further investigation, I know that there was firearms in the car.
Did you search the car?
Yes, I did.
And how did you go about that search?
I searched first the area where I observed Mr. Coates discard his firearm. I recovered a black Springfield handgun from a gun bag. I recovered a magazine in the back passenger seat. Further search of the vehicle led to recovery of a AR-style pistol in the trunk with a drum magazine and a standard magazine, both fully loaded with 5.56 caliber ammunition.
Did you find anything else?
That's my recollection. Not that I recall. If I can refer to the report.
Yeah, for sure.
I just recovered the gun. Yes.
What was the result of that?
The firearms came back registered into the post.
Did it show that he had CPO? What happened to the weapons?
They were placed on evidence at the 11 precinct.
I have nothing further, Your Honor.
You're familiar with Mr. Covey, correct?
Generally,
You've observed him in the Greektown area before.
yes.
He routinely open carries,
Yes.
so you know him to possess firearms.
Yes.
And you said that you saw him reaching to the back seat of the Jeep, correct?
I say he was placing his gun in the back seat.
Right. And that you recovered the gun from the back seat.
The mag was in the back seat, the gun was in the trunk. And when he reached back in the back seat, he just put the gun in the bag and tossed it back.
You wrote a report in this case,
Yes.
and it included all important details, correct?
Right.
And you remember it was fresh at the time that you wrote that report, correct?
Yeah.
You knew it would be relied on by the prosecutor's office in making a charging decision.
Correct.
And you knew that you might need it to refresh your recollection if you were called to testify.
Correct.
So it included all important details relevant to this case.
My best knowledge, yes.
There's nothing in your report about Mr. Covey making a throwing motion of a gun case to the trunk of the car.
May I review my report? Have it here. I just wrote down that I lost visual of the gun bag after he placed the gun inside.
From the time that you shined your flashlight into the car to the time that your partner made contact with Mr. Covey on the driver's side, less than 5 seconds elapsed.
I don't recall how fast my partner moved around the car.
But it was immediate, right? You shine your light in and your partner made his way to the passenger side of the car.
I don't recall.
Would watching your body worn camera refresh your recollection?
Possibly.
May I approach your honor?
Yes.
You recognize this?
Yes.
Is this your body worn camera from the night in question?
Yes, it is.
And you're walking northbound on Brush, is it?
Yes.
Shine your light. 1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000.
Okay. So is that good?
So it's your testimony that you observed a handgun in Mr. Covey's lap. And in less than 5 seconds, he has unloaded that gun, placed it in a gun bag, and that gun bag ends up in the trunk of the car.
Yes.
And you did not see him throw it.
The bag disappeared from my visual. There was a lot of
So
moving
you're
parts.
standing on the passenger side window illuminating the vehicle.
Yes.
And you somehow don't see a gun bag flying through the air from Mr. Covey's hands somehow into the trunk of the vehicle. Over the back seat, landing in the trunk.
Well, it's not enclosed, right? It's a Jeep, so you can.
I understand where the car is. I'm just saying, your testimony earlier was that you placed the gun in the back seat and that's where you recovered it from. But in fact, you recovered it from the trunk and it was in a gun case.
The air pistol was in the trunk.
And as was the other gun, correct? Refresh your recollection from the report.
Correct. In the trunk.
So again, it's your testimony in less than 5 seconds. Mr. Covey took a gun from his lap, unloaded it, placed it in a gun case, zipped and closed that gun case, and then was able to toss that gun case into the trunk of the car without you noticing.
I didn't say I didn't notice. I saw him take the gun from his lap, drop the magazine, put it in the gun case, zip it up, and from there I lost visual of the gun case.
Okay. There's nothing in your report about observing Mr. Covey placing a gun in a gun case, is there?
I refer to my report.
You may.
So you placed the handgun in the black bag in the back seat.
And it wasn't in the backseat, was it?
Initially, it was. When I first initially saw him take his gun from his lap, and he fiddled with it in the back seat. He was leaning over the armrest, fiddling with it in the back seat. There was also a passenger in the car. I had to pay attention to a lot of things. I have loaded guns in the car. I have narcotics in plain view. And it's a busy street in Greektown.
Narcotics in plain view, is marijuana an illegal narcotic?
It was a gray area at the time.
In 2021?
Yes. You can't sell it without a permit, you can't smoke it in public.
Was there any smell of burnt marijuana?
Did I say there was?
No.
Okay.
Did you observe anyone smoking marijuana?
Did I say that?
No. But can you answer my question? Was there a smell of marijuana?
No.
Okay, did you observe anyone smoking marijuana?
No.
Okay, and at the time in 2021, was possession of marijuana illegal?
Possession was legal under 2.5 ounces.
Was there more than 2.5 ounces of marijuana in the car?
Didn't weigh.
And you did not charge Mr. Corbett with any marijuana related offenses?
No, I was just testifying to my observations.
But I'm asking, you did not seek to charge, or did you place him under arrest for any marijuana related offenses?
No.
And the guns that were recovered were both registered to Mr. Corbett.
Right.
And they were both in gun cases in the trunk.
Yes.
And in fact, the magazines for both guns were separated from the gun. You can look at your report to refresh you on that.
Yes.
Yes, so they were both unloaded.
Yes.
Okay, no further questions.
You redirect? Yeah. When you say buck mag, tell us what happened.
There's a button on the side of the handgun. You press it, the magazine ejects.
Nothing from you.
Thank you, Judge.
Looks like you have something to say.
I had a lot to say.
Any other witnesses?
No other witnesses, Your Honor. Your Honor, people motion move to have the defendant bound over on both counts 1 and 2, weapons carrying concealed. Reserve argument.
Your Honor, with respect to one count involving the AR pistol that was testified to, it was registered in a gun case, unloaded in the trunk of his car, which is completely legal. And for that count, there was no evidence at any point that it was concealed in any fashion, so the prosecution has not met its elements. With regard to count 2, and I would ask that that count be dismissed. With respect to count 1 involving the pistol that was supposedly observed in Mr. Kobe's lap, it is the defense's position that the prosecution's testimony is wholly incredible. It is not physically possible for a gun to be in someone's lap, loaded, and in less than 5 seconds end up unloaded in a zipped gun case in the trunk of the car outside of the wingspan of Mr. Kobe without the officers observing it being thrown. Neither officer wrote anything in their report about a gun case being thrown through the air, even though one was stationed on the passenger side and the other was on the driver's side with full view inside of the car. This is a gentleman that officers target because they're aware that he exercises his Second Amendment rights, that he routinely open carries in the Greektown neighborhood. As a result, when they saw him in his vehicle, they initiated an investigation, hoping they could catch him doing something wrong, when in fact, both of his guns, legally registered, were being properly transported pursuant to the law. Legally registered guns that are in gun cases in the trunk unloaded are allowed to be transported legally. It's not a violation of the CCW statute, and it's no way illegal. That's what Mr. Kobe was doing, and for that reason, I would ask that both cases be dismissed.
Your Honor, what we have here is a question of fact. The officers testified that they saw a weapon on on the defendant's lap. He went to investigate, and it does not take long for a weapon to be unloaded. The method of dropping the mag, you press the button, mag basically falls out. So there's, as far as that, there's no flying through the air. Probably is an urban exaggeration on behalf of the defense counsel, but the officers testified that not only did they admitted they didn't see it actually go into the back trunk, but the defendant himself said that the gun is in the trunk. So there's enough probable cause in this case to find the defendant over on the charges.
I have a question for count two. What evidence presented?
Yeah, count two, I'll stick to it being dismissed.
Briefly, Your Honor, it's this court's duty under Anderson to evaluate credibility. And I think it's blatantly incredible / physically impossible for the officers to observe what they have claimed to have observed and the gun to have ended up unloaded, magazine separated in a zipped up gun case in the trunk of the car. He told officers that the gun they were looking for that they could not find in the back seat was in the trunk because he was abiding by the law. This is a man who knows his Second Amendment rights. He open carries in Greektown. He had an open carry holster on him, and his guns were properly stored in the trunk of his vehicle. And he was being targeted because officers don't like that this black man open carries an AR-15 pistol in Greektown. So they were waiting to snag him, and they snagged him doing something perfectly legal.
Okay, so I'm dismissing count two. As far as count one, I think that's what we went back to the first. I am not a gun expert. I carry, I have a 9mm Smith & Wesson M&P shield. Carry it on my hip sometimes. Sometimes it'll be in my lap. I have a CPL. I don't think that I would be able to unload. Actually, place that gun in a gun bag, slightly toss it back in the trunk of my car. In 5 seconds, but I would place it back to the car to determine whether or not that officer, one of the officers they saw the defendant with the gun in his lap at one point. He did not provide a CPL. And that was confirmed that he did not have one through the research. So I do believe that conditions at this level should be bound over to the as far as credibility, other people will be Anderson. Attorney Nelson, I understand that I have before I have a mandate to also evaluate credibility, but I don't think that this testimony rose to enough for me to dismiss, and the standard is very high. So I think it'll be the better for you, for the trial fact to determine whether or not the testimony is so, Mr. Kobe, I'm dismissing count two. There was insufficient evidence for that count. For count one, to be bound over to Third Circuit Court for further proceedings. There'll be a written on the information date 1 week from today. That will be June 13th at 9:00 a.m. Okay? It's a yes or no.
Your Honor, I believe he's on a $10 bond.
That was just put on there so that he can be credit for time served. You don't need it? I'll change it to the personal. Anything to receive black, have to use the option.
So he was on a $10 bond?
Yeah.
You said the 15th or the 14th, Your Honor?
Oh, 13th. Okay, so I'll change your bond to $1,000 personal bond. And I'm not sure if you're familiar with tethers, the way they're working right now, it's taking about a week for each tether. So
He's in custody in another matter.
okay. All right. Okay.
Okay, we are on the record. This is case 2356886, the people of the state of Michigan versus defendant 1 Tyrone Oliver, defendant 2 Mercedes Smoot, defendant 3 Kelvon Cockrell. Defendant 1 is charged with count 1 controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic 50 to 449 grams. Defendant 1 is also charged with count 2 controlled substance, delivery, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Defendant 1 is also charged with weapons, firearms possession by felon. Defendant 2 is charged with count 4 controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Defendant 2 is also charged with count 5 controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Defendant 3 is charged with count 6 controlled substance, possession, non-narcotic substance added to Schedule 1, 2, 3, or 4 by rule. Defendant 1 is charged with counts 7, 8, and 9, all weapons, felony firearms. Defendant 1 has an official offender enforcement offense notice, and defendant 3 has an official offender enforcement offense notice set for exam appearances.
I'm Daniela Parrish on behalf of the people, P85495, on all 3 defendants. My only request is that if we could work our way backwards, if you wouldn't mind, Your Honor, and deal with defendant 1 last, because that one, there will be some, I don't want to hold everybody else up, that one will be some lengthy changes.
Okay.
And good afternoon, Your Honor. Harold Collins, P56805, on behalf of Mr. Tyrone Oliver, who is present standing to my left. What's your name?
Tyrone Oliver.
And good afternoon, Your Honor. Alexander Cho with the Neighborhood Defender Service in Detroit, P85948, appearing on behalf of Mr. Cockrell, who is also present in the courtroom. Mr. Cockrell, please say your full name for the record.
And good afternoon, Your Honor. Robert Jersey, P13195, on behalf of Mercedes.
Both of them, defense counsel, could you, no, she couldn't hear you. Do you mind?
Robert Jersey, P33195, on behalf of defendant Mercedes.
Who was not present,
Who's not present.
and have you had any contact with your client?
I have not, Your Honor. I've tried calling her, I've sent her letters to no avail.
Okay.
There were 2 different phone numbers in the discovery, and one of them may be a transposed number, but I tried calling both of them. Either no response to either. There's also 2 addresses in the discovery materials and sent correspondence to both addresses.
Okay, so let's deal with Mercedes Smoot first. Is there anything for the people regarding Mercedes Smoot?
Yes, Your Honor. People request the habeas issue.
I'd ask if this matter could be adjourned, or if I'm able to locate her within the next couple of days, I walk in.
Yeah, people have no objections to a walk-in at a later, or within a week.
Second option is more feasible, what I'm willing to do. I will issue a habeas. It will be $2,000 cash surety, and if you do find your client, you can bring her in, schedule a day to walk in, and I'll handle her right now.
Thank you.
Okay, so for Mr., is it Cockrell or Cockrell?
No, it's all right. Copy.
Cockrell, okay. So I have a waiver form before me, is it correct, Mr. Cockrell is going to waive his exam today?
Yes, Your Honor.
Any objection from the people?
No objection from the people, Your Honor.
Okay, Mr. Cockrell, I'm going to ask you a series of questions. If you can't hear me, or if you don't understand, let me know, okay? You have to speak up and have to hear audible response for the court, okay? Did you wish to waive your preliminary exam today?
Yes, ma'am.
You understand that you have a statutory right to a preliminary exam?
Yes, ma'am.
And that if you were to demand that exam today, the people would have to show as a probable cause standard, which is a much lower standard in criminal law, but still a standard, that those charges I read off associated with you were committed in the city of Detroit, and that you probably committed those crimes. Do you understand that?
Yes, ma'am.
And then by waiving your exam today, that means that people do not have to present any evidence today or prove anything today. Do you understand?
Yes, ma'am.
And knowing that information, do you still wish to waive your exam? Do you also understand that you're not waiving your right to trial?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam today?
No,
Did anyone promise you anything?
no.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for the remainder on the information. Your date will be June 13th at 9:05 a.m. And glad to speak to you.
Sir.
All right, Mr. Joe, please say.
Are we in contact?
Okay, you just have left Ms. Oliver.
Yeah, I was just trying to get the information that we wanted.
I'll allow council to separate with Ms. Oliver and one come to the table.
You just gotta wait.
Thank you, Your Honor. People are prepared to move forward with the exam, however, due to information provided to prosecution, let me start by saying, count 3, weapons, firearms, possession by a felon. At this time, the people have insufficient evidence to move forward on that charge, which would then affect count 7, 8, and 9, for defendant number 1. And therefore, the people have no argument to a dismissal without prejudice based on the fact that not move forward at this time. And I have debated to defense that if at a later date, the necessary evidence that may be forthcoming, that police can reissue at that time, but as of right now, we have to move forward on that charge. As far as count 1 and count 2, due to some insufficient evidence, and it was noted prior to the warrant prosecutor, these charges should be possession, not delivery, or manufacture. Let me get the correct MCL for you on the record. Therefore, count 1 should be amended to be controlled substance possession of fentanyl of 25 grams, 49 grams, under 50 grams. And that is MCL 333.74032A4. And count 2 should be amended. It is also should not be delivery or manufacturing, but should be controlled substance possession less than 50 grams. Possession of, oh, and I apologize, Your Honor. Possession of a mixed substance containing controlled substance cocaine. Less than 50 grams? Yes, Your Honor. Therefore, I spoke to defense. They've indicated with the correct charges and the it just count 1 being possession, count 2 also being possession. Their intent is to waive. And that is why I wanted to make sure that everything is correctly put on the record.
Okay. Let me make sure I have it correct. So people will be dismissing count 4, 7, 8, and 9, and amending count 1, controlled substance possession, fentanyl less than 50 grams, and amending count 2 to controlled substance possession, cocaine less than 50 grams. Is that correct?
Yes, Your Honor, correct. Thank you.
And what is the statute for count 2?
It is technically, I believe it is actually the same.
Oh, it says less than 50 grams.
Yes.
Okay, all right.
333.7403284.
Thank you. Okay, Mr. Oliver.
How you doing today, ma'am?
I'm fine, how are you?
I'm all right.
Collins, is it okay if I can waiver? Or
Yes, Your Honor.
Anything else?
He understands his statutory right to hold an exam, and he has decided to waive that right to these amended charges.
Okay. Mr. Oliver, I'm going to ask you some questions. If you can't hear me, or if you don't understand, let me know, okay?
Yes, ma'am.
Is it your wish to waive your preliminary exam today?
Yes, ma'am.
You understand that you have a statutory right to an exam?
Yes, ma'am.
That if you were to demand an exam today, the people would have to prove at the probable cause standard, which is a much lower standard, than criminal law, but still a standard, that those now 2 charges that were amended were committed in the city of Detroit, and that you commit those crimes. Do you understand that?
Yes, ma'am.
And then by waiving your exam today, that means that people do not have to prove anything at the probable cause standard or present any evidence today. Understood?
Yes, ma'am.
And you also understand that you are not giving up your right to trial?
Yes, ma'am.
And knowing that information, you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam?
No, ma'am.
Did anyone promise you anything?
No, ma'am.
Okay, I find your waiver to be really understandingly and voluntarily given. Your regular information day will be 2 weeks from today, so you June 20th at 9:05 a.m. Frank Murphy Hall of Justice. Anything else? Mr. First?
No, Your Honor.
No, Your Honor.
Nothing from the bench, thank you.
Thank you. I will fill out the dismissal for the dismissal.